Hey guys, how are you guys doing? Let's see. Hello. Let me say hello to people in the chat. Hey Kimberly. Hello Black Beauty. Hey Mika. Hello Lady Coltrane. Hey Pretty Brown Eyes. Hello Jay the Great. Hello Toria. Hey Bree. Hey Vivian. Hello Janika. Hello Sierra. Hey Demetra. Hey Perspective Me. Hi Ruby. All right, guys. It's 32 of you guys in the chat. Come on and hit the like button for me. I am waiting for Mr. Rod. He's in a bad area. We talked this morning, and he wanted to come on and talk with you guys. Hey Tina. Hello. I don't know what's going. You know these things, Cole. The phone. I don't know, but I did ask you guys if you want me to go ahead on and come on in. I did send him the link. He has the link, and I also sent Mr. Jeff. Mr. Jeff is not, scheduled to come on, but I also sent him the link as well, just in case he wanted to come in and say something. But I did. He's having difficulty getting in. Hopefully he'll get in. That is, I hope he gets in. But while we wait, I do have some things I wanted to give you, some information, some updates I wanted to give you in regard to the case. This is with the YSL case. Some of you guys have heard of some motions that was recently submitted that have not been addressed by the judge. There's a lot of motions that has not been addressed, at least 20 of them, I think, at least 20 of them that have not been addressed by the judge. And one in particular is the one with the Percocet. Remember that one? That still has not been addressed. Remember that? The motion for speedy trial just was submitted recently. There's 15 likes. Okay. Well, once I get my guess in, I'm gonna put on my marker just in case, because I'm trying to make sure no one takes the items off. But I'm gonna let's see. I don't know what's going on with his connection. If his connection continues, I'll just change the title and end the live. If it's still a problem for him to get on. But I'm gonna text him right now and see what's going on, if he's gonna be able to make it in here. Hold on a second. Okay. But anyway, there was some motions that still have not been addressed. But the most recent one, I don't know if you guys got a chance to look at my live yesterday, and I discussed the speedy trial motion, and I gave you guys some of put it in subscriber mode. Okay, I'll put it in subscriber mode. All right, Toria said put it in subscriber mode. All right, just give me a moment. Let me just take my camera off of me right now, and let me put it in subscriber mode. Just 1 second, guys. Just 1 second. All right. Just 1 second. Just 1 second. Sorry. I should have did this earlier, right? Instead of waiting till now to put it on subscriber mode, but I'll get it done. Okay, let's go ahead and do this. Just bear with me a second as I put it on subscriber mode. All right. Okay. Customize subscriber mode. Okay, I'll put it on subscriber mode, so it will be on subscriber mode. Okay, it's on subscriber mode. Let me go ahead and make the phone call now, see what's going on. If not, we'll just 1 second. I'm on mute for a second and let me know. Hold on a second. I'll let you guys know. Hold on. Okay, I'm still not I'm not able to reach. I don't know what's going on. But anyway, good afternoon everyone. Hope you're doing well. I'm doing well, Coco. I was supposed to have a guest, and he contacted me earlier, and he wanted to do a live, and I said okay. I wasn't feeling too well, but then I said okay. But now he's not able to. I don't know what's going on. You know, whenever you're in the boondocks, he was in the boondocks, like far away, and that's why he had said 4 o'clock, and he probably still having, connection issue. But I came on because y'all said to come on anyway, so that's why I'm here, and hopefully he'll get out the boondocks. I say boondocks, it's like far away. Where he is. He had a meeting this morning. But anyway, let's I do have some things that I can keep you guys occupied until my guest comes. Just bear with me a second. As I was saying, there was a motion that was submitted by by one of the attorneys, Shannon Stillwell's attorney, and I want to bring the guys. I mean, there's a lot that I have for you, but I don't want to say anything until he brings it up. You know how I do. I don't say anything unless I have some concrete evidence of it and certain things, and he mentioned some things, and I would let him speak about it, not me. I can tell you about stuff that's on docket and stuff like that, but anything else, I don't have that privilege to tell you. But I want to bring something to your attention. You guys know about the basketball player that I'm gonna play a clip it from you for y'all. Hey Dom, he's not here yet. He's not here yet, Dom. I was trying to he's in the boondocks somewhere, but I want to play something for you guys. I don't know if you guys know the basketball. His name is Javaris Crittenton, something like that. And he had a case, and he's in fact in prison because somebody had robbed him. My play go back. Don, he ruined his. Come, Don. Let me put the link in here for you, because you know a little bit more about it. But I just learned about it today, and I think they're trying to to bring him as the prosecution getting their wish. The trial's not getting started for months down the road. But see, Toria, there's a problem with that. I don't know if you guys got a chance to listen to my live from yesterday, but I can't come right now, so I'm available in the next hour. See, nobody's available right now. Maybe I should just end this live because my guest is not is having some difficulty wherever he is. Probably connection is bad because you know in the boondocks there's always bad connections, and so I should just end it. Let me end it. Let me end it on the Twitter side. Let me end it. I'm gonna end it on Twitter. Twitter, if you're over there, I'm gonna end it. Come over here on this side. So I ended it on Twitter. Oh no, not Jay, not the guy that put a gun to his head at the club. Not him. Not him. I heard about him too. No. I'm talking about the other one. Jarvis. I think that's his name. Not Jay Morant. Hold on, y'all. Hold on. Hold on, y'all. I apologize. This is one of those impromptu live. But Tanya is a different play. I'm just speaking about the current situation of Jay. I know who she's speaking on. Yeah, that's the one. Crittenton. Well, yeah, that's the one I'm talking about, Dom. You know exactly. But the other one, the Morant one, Jamorant, whatever his name is. I'm not talking about him. That's the one who put the he's is who she's speaking about. He was sentenced for 23 years and 17 of it was he has 17 probation years as well. The young lady got she was killed in a drive-by because somebody tried to rob him, and somebody broke in his house and robbed him or something like that, and then supposedly the guy did it was the girlfriend of the guy who did it, supposedly, allegedly. And in fact, the guy is deceased that supposedly did it. Oh, you put in the guy. Okay. No, that's not who I was talking about. Not the one that's trending right now. The one that's trending right now is he's the one who slapped the boy like 12 to 17 times. And he had a gun. He supposedly had a gun. And then at the club last night, he was dancing with his shirt off and everything. And he put the gun to his face or head or something like that. Hey, Kitty Queen. That's not who I'm talking about. I'm talking about the one that that's from Cleveland Avenue, and they adding him to the case. Well, they're not adding him to the case. They're his name is mentioned in the document. So, and I was bringing him up because someone did a video on him about 11 days ago, and I came about it. It's like everything that has to do with YSL, it comes to my phone, and I guess because that's what I'm working on. But I'm gonna play the video of the guy itself. This happened back in 2012, if I'm not mistaken. 2012. I guess they're gonna pull him to testify. I don't know. Javaris was drafted by my team. Yeah, the Lakers. He was drafted. He also played for Toronto, and he also played for the Wizards. See, I did my homework, y'all. I did my homework. Even though I don't know much about him, but I did my homework on that. I'm gonna play a clipping from it because I screen recorded an article on him. Just 1 second. Just 1 second. I did it today. Trying to find it. Screen record. There we go. I got it. All right, here we go.
Wednesday and faces 23 years in prison. The former NBA player Javaris Crittenton pleaded guilty to manslaughter Wednesday and faces 23 years in prison. The former first-round pick admitted in court to a role in the 2011 shooting death of Julianne Jones, a 22-year-old mother of two. Opening arguments in the case were expected to begin Wednesday before Crittenton suddenly decided to plead guilty. He admitted in court to being a gang member and gave a tearful apology to the family of Jones. The 27-year-old was best known to NBA fans for his role in the infamous confrontation with former Wizards teammate Gilbert Arenas, in which both players admitted to displaying guns in the locker room. Shortly after signing with the Lakers in 2007, Crittenton joined the West LA street gang known as the Mansfield Gangster Crips.
So that's the guy I'm talking about. In fact, yes, you're right. He did plead guilty. And guess who was his attorney? Brian Steele. Brian Steele was his attorney at the time. If you guys, let me put him up so you guys can get a chance to see who I'm talking about. Hold on a second. Hold on a second. Okay, this is Rebound. I'm gonna show you that. OYSL Slugs robbed him. Oh, you guys know a lot about this, huh? Hold on a second. Let me just play it here. This is him right here. He was a player in the NBA.
Star, playing alongside Kobe Bryant.
Over the shoulder on a reverse, no look. Javaris Crittenton and Kobe, you like it? I guess so.
To a notorious gangster facing life in prison for murder.
You said you know who did the shooting?
Yeah, the basketball player, Crittenton.
This is the story of Javaris Crittenton. Javaris was the last person you'd expect to become a murderer, because growing up in the projects of Atlanta during the early 2000s, he was a straight-A student, class president, and a basketball phenom. In fact, by the time Javaris graduated high school in 06, he was a McDonald's All-American and received a D1 scholarship to Georgia Tech. And after only a year playing college ball, Javaris earned his greatest achievement yet, being a 2007 first-round draft pick for the LA Lakers and signing a $2.6 million contract.
Yeah, I was just excited, to be a Laker.
You can't even walk in the building, you're stormed by fans.
At just 19 years old, Javaris was an NBA star, playing next to Kobe Bryant. He was on top of the world. But one night changed everything.
Okay, we gotta put the thing on.
See, one night during his first offseason, Javaris was out partying at the Block nightclub in Hollywood when someone caught his eye from across the room. Famous Atlanta rapper, Dollar, surrounded by his crew, flashing diamond chains, beautiful women, and designer clothes. And young Javaris was mesmerized, so he decided to introduce himself, only to find out that Dollar and his crew were part of a notorious LA street gang, the Mansfield Gangster Crips. And with Javaris being a professional athlete and all, he should have just walked away right then and there. But instead, he was so enticed by the gangster lifestyle that he hung out with Dollar and his crew all night long. And over the next couple of months, Javaris grew even closer to the gang, until eventually he became an official Mansfield Crip. Now, Javaris may have been making waves on the streets, but his basketball career was a completely different story, because after joining the gang, Javaris was never able to gain his footing in the NBA. He went from the Lakers to the Grizzlies to the Wizards, all in just his first 2 seasons, And in December of 2009, his struggling basketball career went completely off the deep end. During a team flight to Washington, Javaris decided to pass the time by gambling on card games with his teammates. And after losing thousands of dollars, Javaris was pissed. So in the heat of the moment, he ended up getting into a fight with his teammate, Gilbert Arenas, threatening to rob the guy. Javaris' inner gangster was showing, and he wanted to settle the beef like a real Mansfield Crip. So a couple of days later, Javaris pulled up to the Wizards arena and walked into the team's locker room with a loaded weapon. And after a heated exchange, Javaris found himself in a Wild West standoff with Gilbert Arenas. Now luckily, both guys eventually calmed down and no one ended up hurt. But that didn't stop the incident from being reported to the police. So a few weeks later, Javaris was charged with misdemeanor possession of a firearm and was sentenced to 1 year probation. And following his sentencing, Javaris' contract with the Wizards was terminated. After just 2.5 years, 22-year-old Javaris was officially out of the NBA. This seemed like rock bottom, but in reality, it was just the tip of the iceberg. See, getting kicked out of the NBA left Javaris devastated, so he decided to fly back to Atlanta, looking for the support of his family. But what he got instead was judgment and rejection. The people that once saw him as a hometown hero now saw him as a failure. And as a result, Javaris turned to the only people that he felt would accept him, the Mansfield Gangster Crips. And by spring of 2010, Javaris had become a ride-or-die member of the gang, going as far as helping the Crips duck police and even putting money in their jail accounts. But eventually, all of his boys got locked up. So when no one else to turn to and nowhere else to go, Javaris decided to make a last-ditch effort at an NBA comeback, trying out for the Charlotte Bobcats, only to fall flat on his face. By 2011, Javaris felt alone and hopeless. At just 23 years old, he had no job, was rejected by his family, and his closest friends were dead or in prison. Feeling like he had nothing else to lose, Javaris became a ticking time bomb, ready to explode at any moment. All he needed was a little push over the edge. And that push came on a dark Atlanta night when, after leaving a local barbershop, Javaris was robbed of everything he had on him. His $25,000 black diamond necklace, his $30,000 black diamond watch.
Wow.
I mean, he even got robbed for his iPhone and $25.
Wow.
All by a rival gang member that Javaris recognized. 17-year-old ROC crew member, Lil Tick. And after everything Javaris had been through, this was the final straw. He wanted to find Lil Tick and get revenge. On August 19th, 2011, at 9:30 p.m., Javaris was in the backseat of a rented Chevy Tahoe with his cousin Scooter up front, driving him to Lil Tick's last known location, Glen Rose Heights, just outside of Atlanta. And as he turned on to Macon Drive, Javaris spotted this target on the sidewalk and opened fire. But instead of hitting Lil Tick, Javaris missed and accidentally hit an innocent woman. So with this, panicked Javaris Crittenton fled the scene as witnesses called the cops. After medics arrived, the woman was rushed to Grady Memorial Hospital, where just 2 hours later, at 11:34 p.m., she was pronounced dead, making Javaris Crittenton a stone-cold killer.
Atlanta 911 emergency operator 44.
Send the police to make them drive. When they had a drive-by. You said you know who did the shooting?
Yeah, the basketball player, Crittenton, Crittenton.
Hey guys.
Just a few days after the murder, Javaris fled to LA as police began their investigation. And over the next week, they gathered tons of evidence linking Javaris to the crime. Witness statements, his photo being picked out of a police lineup, and the discovery of the rented Chevy Tahoe coated with residue and Javaris' fingerprints. So police obtained an arrest warrant, and a couple of days later, the FBI arrested Javaris in LA. But it wouldn't be until April of 2015 that his day in court would finally come. By this point, there was so much evidence against Javaris that a life sentence seemed inevitable. So on the very first day of his murder trial, he struck a deal with prosecutors. In exchange for dropping several charges, Javaris pled guilty to aggravated assault with a firearm and voluntary manslaughter. And as a result, he was sentenced to 23 years in federal prison. So, as of this recording, Javaris is being held at Calhoun State Prison in Georgia, where, pending good behavior, he has an expected release date of December 13th, 2036.
All right, that's him. That's him, y'all. That's the guy I was talking about. And I happened to see, I think it's on the 1 sec, hold on. Okay, right here. One second. It's on Urban True Crime here. I'm going to show you guys what it shows here on Urban True Crime. Okay, Urban True Crime shows that right here. You see here? It says in details that most missed in the YSL indictment. Okay. It says on May 9, 2022, the leadership of the famous wise young stoners like record label was indicted in an almost decade-long Georgia State RICO case, seeing the arrest of 28 people in Atlanta. Included in the YSL indictments are several well-known Atlanta area rappers who has gained international fame over years, like Sergio Gunner Kitchen, and Martinez Little Duke Arnold, right? Colin Jeffrey, Young Thug Williams, the leader of the orchestrated Atlanta blood gang called Slime Life, Young Slime Life. An 88-page indictment is an overwhelming list of evidence that goes back 9 years, starting with an indictment in 2013 where YSL Associated pointed a gun at a man. There are several murders and several attempted murders involved, as well as murder, conspiracy, shooting, robberies, burglary, auto theft, dealing and buying of drug, and most currently a huge list of racketeering charges that are based solely on music videos and vague social media posts, right? And here then it says most rapper fans paying attention to have probably seen the YSL rapper DeMonte Yak Gotti Kendrick standing with YF in Lucci's car and consider it overwhelmed for furtherance of the conspiracy. Furtherance of the conspiracy in the indictment, as well as the fact that Yak Gotti is charged with murder of Donovan Nutt Thomas, a prolific Atlanta blood that was killed in 2015. And most notably, Young Thug is accused by prosecutors of renting the car and using the murder, that he is not charged with the murder itself. Among these charges, the 88-page YSL indictment contained a slurry of evidence and details that have totally overlooked most, right? So here, okay, now this is where Jarvis comes in. Okay, Tick Stephen was involved in an incident in 2011 where he supposedly robbed a former NBA player, Javaris Crittenton, at gunpoint. This armed robbery is what led to Crittenton shooting and killing a 22-year-old Julian Jones by accident. Tick was the target of the retaliation shooting that night, and Jones was merely sitting next to him. Crittenton was sentenced to 23 years in prison in 2015 after pleading out for manslaughter in the case. The prosecutor has plenty of evidence over the years showing that Young Thug was influential in the commission of violent acts and overall functioning of the organization. Most fans probably heard that Young Thug was alleged in one count to have told his underlining that they are getting soft for not having shot or at least beat a certain individual over presuming wiretap line. Beside the evidence of the furtherance of conspiracy, Young Thug is implicated in a huge variety of crimes such as drug possession and sale, a few with Gunna, and many specific incidents of alleged racketeering, general gang activity. At one point, the state shows evidence of recording conversation between Thug and Kyle Ori, an alleged leader of a sex money murder faction. This brings up several names of other gang leaders in Georgia and state explicitly nobody under one of these individuals in the state of Georgia must line in. Pete Sapp. On September 9, 2013, among the very first charges listed in the indictment, Young Thug is alleged to have committed a crime of theft by receiving stolen property. They are accusing him of unlawfully possessing a gun that was stolen from a victim named Ann Phillips. YSL's associate Walter Murphy publicly flaunted a tattoo on Instagram 8 years ago and supposedly of evidence of the furtherance of the criminal conspiracy and not just the mere potential existence of one. It appears that Young Thug is referring Trontarius Tick Stephen by name as one of his songs. The state supposedly has evidence that the individual who stabbed Rayshawn YF and Lucci Bennett in jail are not only YSL's associate, but made communication to Young Thug while in jail, inquiring about both permission for the hit, which was unsuccessful, of course, and also payment. Okay, this is what it all says here. All right. Okay, this is Lil Rod right here. Teenagers killed in shooting at Atlanta apartment identified. Let's see if we play that. Can we play that one? No, we can't play that one. This is Lil Rod. At age 11, shown a missing child in 2011. Lil Rod was shown as a missing child. Let me go see what that is all about. Can you guys still see this? I can't even see that one. Okay. I can't see that article. He says Lil Rod 11 was seen riding his bicycle along Cleveland Avenue Saturday. Read the article. Let's see. The page is gone. It's gone, y'all. I can't read that page. All right. Okay, what somebody's put down? It says, hey, everybody want to be a gangbanger. Jay, when my kids were young, I taught them not to look at these sports people or rappers and made them focus on the books and their education. These people are not role models to me, none of them. Damn, you sound like that. I sound like what? Well, I sound like that. I'm not feeling too well. He says, "What? You sound like that." I'm sorry. I'm sorry. I came on because he was missing at 11 while riding his bike late at night. Let me see what's going on. What happened to them? If they still. Hold on, I got mute for a second. Hold on. Sorry, guys. I'm still not able to get him. He's probably out of range. So I'm gonna is there anything else? And I just brought that guy up because it was there was a thing that was popped up and I looked it up and saw that they was putting him as part of the case some kind of way, but I don't think he's part of the indictment. Official Payne is here. Hey, King Payne. How are you, honey? I was waiting for my guest to come on, but they're having connection problem because he had told me he was all far away, but he asked me to because he wanted to say something, and I said sure. And when I set it up, sent him the link, he started having a problem with his connection where he's at. So I was just trying to kill some time by giving you guys some stuff that I received on the internet today earlier. And the guy, that basketball player, was named somewhere in this case. And also I talked about the motion that was submitted by, well, I could put that up, right? Maybe I could just put that up. Let me put that motion up. Yeah, I am like so like worn out. I just need to rest. My body's like, and that's all I did this afternoon. I mean, this morning is just rest. I'm trying to pull this up for you guys. I'm telling you, I do not know how to use these this thing here. Okay, hold on. Let's pull it up. I want to see what was yesterday's date. Okay, let's see. Go 1 second, guys. I'm trying to find out what was yesterday was what, the 5th? 5th, right? I saved it somewhere. I think I found it. Hold on. No. Yes, it was the 3rd. Okay. No, today's what, the 5th? Oh my God, I'm so like messed up with the dates. It's on my what's the name? Hold on, let me just pull it up. Let me pull it up. Let me pull it up. Cancel. Today's the 4th. None of us know today's date. What's wrong with this? Did you see Tennessee ban drag shows? What's a drag show? What's a drag show? What's a drag show? Yeah, I'm being slow today. Seriously. I don't know what happened. Let's see. Hey, Sharon. I was trying to pull it up for y'all. Hold on. There we go. I got it. All right. This is what I was trying to show you guys. A speedy trial. Let me put my my thing up so people don't try to steal my stuff. Hold on a second. Pour my water maker. No, cancel. Hold on. Watermark. Just 1 second. Oh, okay. I'm just going to show it to you this way because it's not downloading. And I'll just show it from my banner thing here. 1 second. I'll put my overlay on it. Then I'll show it to y'all. All right, here we go. This is the motion that was submitted by the attorney, Shannon Stillwell's attorney. You see it? This is it that was submitted, and it has to do with speedy. Oops, why is it? Oh, what is that? What is it doing that for? All right, here we go. Oh, what is going on here? It's acting up, y'all. All right. It says State of Georgia versus Shannon Stillwell, defendant, and he has a case number. Judge Glanville, and it says here, demand for a speedy trial comes now defendant Shannon Stillwell, and by and through his undersigned counsel, and while there is jurors in panel and qualified to try the case at this term of court, makes this demand for speedy trial in accordance to OCGA 17-7-170 and OCGA 17-7-171. The defendant asks that the demand to be placed on the minutes of the court and that the defendant be tried before more than 2 terms of a court are conveyed and adjourned, or in default such trial. I gotta move down. It's not letting me move down. Okay, I have to make it smaller. Sorry, guys. It says here The defendant asked that the demand be placed on the minutes of the court and that the defendant be tried before more than 2 terms of court are conveyed and adjourned, in default of such trial, that he be fully acquitted and discharged of offense. COGCA 17-7-171 and Walker versus State. So we're going to go see what 17-7-7171 is saying. What is that all about? Just one second. Let me take the overlay off my face. Take that off my face. Okay. Let's go see what that one says in that 17 OCGA. It's 7-17-171. Okay, that's that one. And according to Google, it says the OCGA 17-7171, it says A, does not require the jury to be in panel at the time of the demand is entered in order for the demand to be timely. It simply requires that the demand be entered either at the term of court or at which the indictment was found, and next succeeding regular term thereafter. So let's see what else it's saying here. Okay, this is what it says here. It says 2010 Georgia Code, Title 17, Criminal Procedures, Chapter 7, Pretrial Proceeding, Article 7, Demand for Trial, Announcement of Readiness for Trial. 17-7-171, Time for Demand for Speedy Trial in Capital Cases, Discharge and Acquittal, where no trial held before end of the second term of the demand, counting of term in cases in which death penalty is sought. Okay. Let's go down a little bit more. It says here, you guys seeing this, what I'm talking about? Oh. Dom, don't put that dude name in my chat. Please don't put that dude name in my chat. Don't put his name in my chat. Guys, I want to stay away from the drama, okay? Keep that name out my chat, please. I appreciate that. This is not the time for that nonsense. I'm not entertaining nonsense with that dude. All right. It says here, a person accused of a capital offense. Okay, it says, let me start at the top. A case where death penalty, I don't think is a death penalty being requested on this case? No, right? But anyway, let's go ahead and read this. Time for demand for speedy trial in a capital case, discharge and acquittal where no trial held before end of 2 court terms of demand, counting of term in cases in which death penalty is sought. A, any person accused of a capital offense may enter a demand for speedy trial in that at that term of court at which the indictment is found. So I guess during the indictment, or the next succeeding regular term thereafter, or by any special permission of the court. The defendant may, at any subsequent term thereafter, demand a speedy trial. The demand for speedy trial shall be filed with the clerk of court and served upon the prosecutor and upon the judge to whom the case is assigned, or, if the case is not assigned, upon the chief judge of the court in which the case is pending. A demand for trial filed pursuant to code section shall be filed as a separate, distinct, and individual document and shall not be part of any other pleading or document. Such demand shall clearly be titled Demand for Speedy Trial. Reference in code section within the pleading trial shall be binding only to the court in which such demand is filed, except where the case is transferred to one court to another, from one court to another without request from the defendant. B. If more than 2 regular terms of court are conveyed and adjourned after the term which the demand of a speedy trial is filed, the defendant is not given a trial, then the defendant shall be absolutely discharged and acquitted of offense charged in the indictment. Did y'all hear that? Did y'all hear that? Guys, did y'all hear that? Did y'all hear that? People don't want to be educated, do they? They just want sensationalized stuff to be utilized someplace else. So did y'all hear that? So they should be absolutely, right here, it says it right here. It says, then the defendant shall be absolutely discharged, acquitted of offense charged in the indictment, provided that both terms there were a jury impaneled and qualified to try defendant and provided. Provided that at both terms there were juries impaneled and qualified to try the defendant, and provided further that the defendant was present in court announcing readiness for trial and requesting a trial on the indictment. So if the defense is ready and the prosecution is not ready and the jury has been impaneled, so guys, the jury hasn't been impaneled, has it? Hey, Janice. So the jury has not been impaneled. So let's see what's the real definition of impanel. Because, hold on a second. By the second term, impaneled. Impaneled mean enroll to a jury. Enroll someone onto a jury. Several of her friends were been impaneled. Oh, so as long as they're enrolled, meaning the ones that are okay. So they are enrolled because they can't do anything. The judge can't. Wait, y'all. Wait. They are considered impaneled. You know why? Remember. No, listen. The jurors, they can't do anything because they're under obligation of the jury. Because remember all the ones, like if they can't go out of town, they can't do anything because they're obligated as jurors. even though they're not seated, they have been impaneled. Because it says here, impanel means enrolled, enlisted. So, and then what y'all talking about is seated. That's the 12 and the 6. Those are seated. But those that are enrolled or impaneled are potential jurors because they can't do anything. Remember? They can't do anything because they're obligated. Like if they decide to go out of town, they can't go out of town. They're stuck. Remember if they don't show up to jury thing, hearing, whatever, the judge go get them, send an officer out there and go get them. So they're listed, they're impaneled, they're not seated. But that's why I had to go read what definition of what impanel mean. Impanel mean enrolled or enlisted. That's what it. See the definition right there. Oh, right there. Enlisted. See. Enlisted or enrolled. They can't go nowhere unless they get permission from the judge. Remember? They can't do anything because the judge said keep calling that number. You can't talk to anybody, can't do this, can't do that. You're stuck. So therefore, the jury has been impaneled. They just haven't been in says impaneling refers to selection and assignment of a juror for the purpose of deciding the case. And so that means, what does a panel means? It means verbally that they are enrolled in or a panel. So, because you remember they get sworn in. They get sworn in. They all get sworn in before they leave that thing. Once they watch that video and they get sworn in, yep, that is whether or not they keep them. Okay. 2, it says to enter on a list. This is what impaneled means. To enter on a list, a person named to be summoned for jury duty. To be listed. See? Listed on, to be entered, to have your name on the list. Summons. Yeah, they've been enlisted. That's what it is, Toya. They've been enlisted. Their name has been entered onto the list. That's what impaneled. They said the definition of impaneled. And then the other part of it is, I guess, 2 part afterwards. Then there's them being seated. Those are actually seated jurors. Wow, y'all. You learn something every day. You learn something every day. Wow. They haven't even been seated, but are enrolled. Yep, Toya. Because they can't. Because, okay, really, if that person decides to not show up, what happens to them? If they decide not to show up to the jury thing, what happened? The judge sends an officer, go get them. And then they'll be held what? In contempt for not following the instruction of the judge. And then they get penalized. Like that lady, remember she had to write that paper, 30-page paper? The other guy has to go do some community service. You see that? So if you're not, wow. So the court gonna have to be penalized as well because they didn't start the trial. Because they can't do anything that they want to do. Interesting, isn't it, Toya? Wow. Okay. Can speedy trial be denied? According to that, no, because you have a constitutional right. And we can go deeper into this. Let's go back deeper. Let me read it. It says it can't be denied because see, it's a federal law and it's a state. State just make it more specific to that particular state, but everybody, that's part of the Constitution. A speedy trial. That's the Sixth Amendment. Let's go look at the Sixth Amendment. Okay, you see what it says here? Oh, sucky. It says the Sixth Amendment. Hold on, let's go. Let me share that with you guys. Let's go share it. Why am I still got this thing up? Okay, it says here, this is what they said about a speedy trial here, okay? It's part of your Sixth Amendment. It says, the Sixth Amendment guarantees the right of a criminal defendant, including the right to a public trial without unnecessary delay. You hear that right there? This is it right here, speedy trial. Unnecessary delay, and the right to an attorney, and the right to impartial jury, and the right to know who the accusers are. These are all the rights that they have. They have a right to what? No delay in the case. I mean, stop with that long process of juror picking. The right to choose whoever they want as an attorney, has a right to be impartial, right? The right impartial jury, and the right to know who the accusers are. So all those people who had accusers and people that there's been a lot of violation. If you think about Mr. Kelly's case, y'all, there were a lot of violation. Now that we're studying this stuff here, look how long Mr. Kelly's case took. That was a violation. Did anybody put anything in there for that? He was in jail for how long? Almost 4 freaking years. That's a violation of his rights. Come on now. He didn't get a speedy trial. That could be part of his what's the name too? His what do you call it? That motion stuff. The appeal. That could be part of the appeal. He didn't have his Sixth Amendment right was violated. He was in jail for how many years? How many years? And why did his attorneys did not put in for a speedy trial? Violation, y'all. Violation. Sixth Amendment violation. Because they're supposed to be ready. And how many times they did the change of his indictment? They kept changing the indictment, kept redoing the indictment, kept doing the indictment, kept doing it. You can't do that. That man was done dirty. That man was done very, very, very dirty, y'all. I'm going to change my title because we're talking so much about different things. I need to change my title, remove the picture and all that. Change my title. That's why I ended on Twitter. I didn't get my guests didn't show up. Okay, so I like this learning thing here. So we're really getting the nitty gritty of the whole, speaking of Mr. Kelly, y'all, let me pull up something. I want to pull up something. Y'all mind if I do a little teaching for a minute? if you guys mind, I want to pull up something. I want to bring up something to your attention. Hold on a second. I know I'm a pain in the butt. I'm a pain in the butt, but I'm gonna show y'all something. And I started looking at Ghislaine Maxwell's appeal. I'm gonna show you some of that stuff too, guys, because I just feel like I'm gonna change the title. I'm gonna change the title. Let me change it. Let me edit the title right now. Let's change the title. Oh, can't change the title on Facebook. Let me go change the title on YouTube. All right, we're gonna change the title. Trial and trial case. Oh, let's see. Sixth Amendment. Violations. We're gonna call all that. We're gonna call all of these things. Hold on a second, I'm changing the title. Hold on a second, and I'm gonna put. All right, I'm changing it. I changed my picture too. Change the picture. Let's see. Let's just put my logo on it. Let's just put my logo. Okay, we'll just put my logo. Okay, we just changed that. It won't let me change it. I'll change it when I get to the YouTube side. I'll change it on the YouTube side. I can't change it right now. Maybe you can change it later. Yeah, I'll change it later. It won't more. It's not working to change it now. But let me go ahead and bring this up for you guys. This is something I wanted to bring to your attention. Okay. Okay, here we go. All right, let me share this with you guys. Let me make this bigger. Okay. Oh, this is a transcript. No, never mind. Not that. Hold on. This is transcript. I don't want the transcript. I don't want the transcript. I want something else. Hold on. All right. So this is what I want to share with you guys. All right, this is what I want to share with you guys. Okay, this is the original indictment. Well, this is like, okay, can you guys see that? All right, this is the New York indictment for Mr. Kelly, okay? I know I talked about this with you guys before, but I wanted to show you guys something on this, okay? All right. They changed his indictment 3 times in New York and I think 2 times in Illinois. So it's a lot of changes, re-indicting and all that, right? We already know that according to, let's see, New York. What's New York law on speedy trial? Speedy trial. The federal rule on speedy trial. Speedy trial. Federal. Okay, speedy trial requirement. Okay, the federal rule. Let me stop this for a second. And then on here it says here, let's see. Speedy trial in federal court. Okay. In the federal court, right? The Federal Speedy Trial Act provide some instruction for federal cases. For example, it requires a formal charge to be brought within 30 days of arrest, right? And one of the main reasons is the right for a speedy trial is to prevent a defendant from being held in custody too long, only to eventually be found innocent. Okay. So, okay, what does it requires for a speedy trial? Okay. The Speedy Trial Act of 1974, defining the Sixth Amendment rights, the Speedy Trial Act of 1974 mandate that by 1980, the period of delay in all federal district trials shall not exceed 100 days. It should not exceed 100 days. So how many days was Robert held? He was held more than 100 days, y'all. He was held for what? 365 times 4 times 3. Till his rights was violated there. So it's 100 days that they cannot hold him. So that's why they kept saying excludable period of delay, excluded this, excluded that. Okay, here's the 4 criteria to use to determine that trial delay is unconstitutional. Okay, it says 1, the length of the delays, the reason for the delay, the appellant assertion. Oh, they can't appeal it. It is an appealable. It's appealable, y'all. Did you see that? It's appealable. Whoop, 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 whoop. It's appealable. Okay, if you find it is in violation, what happens? Do they get free? Do they get set free? Did they get set free? And prejudice. There's prejudice. There was prejudice. We had that surviving R. Kelly and all that other crap. Let's see one exception. One exception is mistrial. Defendant is unable to appear in trial the date of trial. No, that's not. No, we ain't got to worry about that because it was not. What's another there are a few exceptions to this requirement. Mistrial. Defendant is unable to appear on the date of trial. Defendant needs more time to prepare and gather witnesses and evidence. They didn't gather any witness on his side, did they? They ain't gather nothing. Oh, wow, y'all. It's good to learn that. It's good to learn some stuff. You know your laws, y'all. So the young man asked for a speedy trial. What was the outcome? Still waiting for. No, Sharon. They just put in a motion. They just put it in on the first. So we'll find out. All right, let's go into Mr. Kelly's thing here. Hold on. Sorry. Okay, let's go. So we already know the speedy trial thing did not work out with them, right? All right, let's go. All right, here we go. At all time relevant to this I can't even read. Introduction. This is the grand jury charge, right? And yeah, I want to show y'all something. And this is from New York, right? This is from New York case, right? Remember I went over this and I told you in the beginning there was nothing on Aaliyah. They went and did that. But let me show you also. Let me show you something that happened. I'm going to show you something else that has happened in this case and just wanted to bring it to you guys' attention. Okay. The defendant, Robert Sylvester Kelly, also known as R. Kelly, an individual who served as manager, an individual who served, you hear me, right? And individuals. I'm going to read it again. R. Kelly, and individual who served as managers, bodyguards, drivers, personal assistant, and runners for Kelly. Okay? Who was on trial in New York? Did you see any managers? Did you see any bodyguards? Did you see any drivers? Did you see any personal assistants? Did you see any runners in his case? Did you see any of those people in his case in New York? This is I'm talking about New York. Did you see any of those people in his case in New York? Any of them? Any of them? Did you see him on trial with him? No, right? No, you didn't see none of that. But he got a RICO, right? We talked about this is old stuff, y'all. This is just like a review, a review. But let me show you. This is not what I was showing that for. But this was part of the indictment, right? We all read that, right? And then the purpose of that was to promote his R. Kelly music. And I just don't want to read that part right now. Okay. And when Kelly, and this is another part here. When Kelly identified a woman or a girl who he wished to see again, he either gave his contact information to the girl or woman to obtain her contact information and relied upon the members of the enterprise to do so. Following these events, Kelly communicated with certain of these women and girls by telephone, including through the traditional telephone calls, text messages, iMessages, FaceTime. As part of the communication, Kelly often requested the woman or girl provide him with a photo of themselves. All right, we're going to keep going down. And this is one, I want to point out something. Okay, we don't need to read that part. Okay. The means and method. Okay, we know they did the recruiting, grooming, blah, 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 blah. Now, the racketeering. Now, this is the allegation contains in paragraph 10 through paragraphs 1 through 10, the realleged and incorporate as if fully set forth in paragraph. Okay. Now, this is where I wanted you guys to talk about with you guys, right? If you see count 1, it has nothing. Remember, they changed it and put it bribery, right, in 3. But this one, the first indictment, there was no bribery, right? There's no bribery because you have to have a certain amount of elements for it to be a RICO. And this one here says racketeering, right? All right. So it says here, now look at these individuals that I'm going to read. And you guys, please, 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 please hear me for a minute. In or about and between 1999, right? And the present, both dates being approximate and inclusive, within the Eastern District in New York and elsewhere, the defendant, Robert Sylvester Kelly, also known as R. Kelly, together with others, being a person employed by or associated with the enterprise, an enterprise that engaged in the activities in which affected interstate and foreign commerce, did knowingly and intentionally conduct and participate directly and indirectly in the conduct of the affairs of the enterprise through a pattern of racketeering activity defined in Title 18 United States Code 18, Section 1961, 1 and 1961, 5, consisting of the racketeering set forth below. Okay. Listen. Exploitation of a child, Jane Doe number 1. 13. In or about between May 1999 and October 15th, 1999, both dates being approximate and inclusive. Within the Northern District of Illinois, the defendant, Robert Sylvester Kelly, together with others, did knowingly and intentionally employ, use, persuade, induce, entice, and coerce a minor, to wit, Jane Doe number 1, an individual whose identity is known to the grand jury, to engage in sexual explicit conduct for the purpose of producing one or more visual depiction of such conduct, which the visual depiction were produced using material that had been mailed, shipped, and transported into interstate and foreign commerce in violation of 18 United States Code, Section 2251 and 2251E. Okay. Jane Doe number 2. Racketeering Act 2. 14. In or about and between 2003 and 2008, both date being approximate and inclusive within Northern District of Illinois and elsewhere, the defendant Robert Sylvester Kelly, together with others, did knowingly and intentionally secretly confine an individual, to wit, Jane Doe number 2, an individual whose identity is known to the grand jury, against her will, and induced Jane Doe number 2 to deceit and entice to go from one place to another with intent secretly to confine her against her will in violation of Illinois Code Section 5-10-1 and 5/5-1. Okay. That's Jane Doe number 2. Okay. The defendant, Robert Sylvester Kelly, committed the following, either one which alone constitute Racketeering Act number 3. So tell me, y'all, why did it not include these two particular acts in Illinois? When these two never crossed state line, they were both in Illinois, supposedly, right? Why did they not? Hey, Cynthia, why were they not part of the Illinois case? This is what the judge talked about. And when they asked the prosecution, why didn't they just do this? It could have been done in Illinois instead of New York, right? Because Illinois was really the first one that had the case, that had them arrested. And what they did an arraignment in New York the following month in August. So Illinois was the first ones that had him. So therefore, why didn't they consolidate everything into one at that point of time? Why? Why did it not consolidate it at that point in time? Because the supposedly crime was done in the state of Illinois and not in the state of New York, for those individuals especially. All right. Now, but hold on. Let me ignore these people here because I don't care about them. This is another. The person I want to show you is Jane Doe number 4. Jane Doe number 4 is who I'm concerned about, which I'm going to bring to you guys' attention. And I'm going to bring something to you guys' attention that really should be something you like, okay, why did they change this? And I'm going to tell you why they changed it. Now, this is Jane Doe number 4, okay? You guys remember Jane Doe in the third indictment, the superseding indictment, Jane Doe number 4 changed from Jane Doe number 4 to Jane Doe number 5. And do you remember who that was? Do you remember who Jane Doe number 5 is? Anybody remember? Yes, Nikenya. Let me show you guys how slick and sneaky, and I'm going to get out the way so you guys can see this. How slick and sneaky they were with this indictment, okay? Now, if you notice, Jane Doe number 5 was Jane Doe number 4, right? And this is what they have for the Mann Act. They had Mann Act because this is the one, going across state line and all this kind of stuff, and for the purpose of whatever. Now you see it says here, the defendant, Robert Sylvester Kelly, committed the following act, any one of which alone constitute racketeering Act 7. A, transportation. Like, look at this closely, y'all. Look at this closely. In or about July 2015, within the district of what? Connecticut. Look at this. Connecticut, y'all. The defendant, Robert Sylvester Kelly, together with others, did knowingly and intentionally transport an individual, to wit, Jane Doe number 4, an individual whose identity is known to the grand jury, in interstate commerce, which the intention of engaging what? Sexual activity with a person being charged with a criminal offense, to wit, violation of what? Connecticut General Statute, Section 53H-71A4, sexual assault in second degree. Did you see what they were charging him? What? Sexual assault. Not statutory rape, but sexual assault. But they couldn't fly with that because you know why? It's not illegal. Because the state of Connecticut, the legal age is what? 16. 16, people. So what they had to do? Go back to the drawing board and wipe that one out. And I'm going to show you guys where they wiped it out at in the new indictment, in the third superseding indictment. They took it out. They were fishing, y'all. They was quick to arrest him because they were on a speedy timeline. Because as soon as you have 30 days after what? The person is arrested, you have to charge them, right? So they had to hurry up and give them something. Then they realized that, hey, we can't use Connecticut. You know why? Because Connecticut's age of consent is what? 16. So they wiped Connecticut out and moved it all over to what? New York. But they didn't use her for New York. They put California for her in New York. California, because age of consent in California is 18. Age of consent in New York is 17. So New York was not going to work. So they scrambled and put California in there. And they changed the date. They changed it from being what? July 2015. They changed it all the way to October 2015. Did you see that, guys? They were playing with the man's life throughout this whole time, doing eeny, meeny, miny, mo with this case. There's a lot of reason for appeal. So I'm going to stop this now. I just wanted to share that moment with you guys to show you guys how these people were playing with Mr. Kelly. Okay. Mr. Kelly, I'm telling you, all those who think he's not going to win the appeal, I showed you some examples of him winning the appeals. Just just a little bit that I showed you. And there's a lot of violations. There are a lot of things that has happened in his case that he is going to win his appeal. And I'm not even a lawyer. This was just some nuggets that lawyers has given to me. So that's why when people say, oh, do you think he's going to win an appeal? Absolutely. Absolutely, he's going to win his appeal. Absolutely. That's why they're trying to take their time. Because they're going to put everything in there with the kitchen sink. And I showed you the speedy trial in the other state. Hold on a second. Let me just give you the brief of Ghislaine. Are y'all sleeping on me again? Y'all not even clapping back. Let me go get some clapbacks over here. Let me go get me some sounds in this thing here. Because you guys are not giving me any sounds. Let me go look for some sounds because y'all getting on my nerve. I'm trying to give y'all some good education and y'all not giving me no sound back. Let me see. Let me give me some sound. Oh, let me give me some sound. Thank you. Thank you very much. Thank you very much. Because these people over here is not giving me a sound. Can I get them another clapping hand sound? Come on. Thank you. Thank you. Thank you very much. All right, let's go on to the next one here. Let's go take a look at what Ghislaine Maxwell's Marquita said. All right, there go Ghislaine's. And you see her oh my God, my throat is itching so bad. Oh, I'm getting somewhere. All right, y'all see this? Thank you, Bree. Thank you very much. All right, y'all, let's see. Okay, this is Ghislaine's her brief for her appeal. Okay, remember she went to trial, I think after Robert, and her appeal is already up. Can you believe that? Because they've been lollygagging and hers been up. See, she got approved for appeal, and Robert got approved for appeal as well, but hers is being put in already, and there are 113 pages. Okay, we're gonna go over it. We're gonna take a look. All right. So, all right, here we go. United States versus Ghislaine. I don't know how to say her name. Ghislaine Maxwell, aka Sealed Defendant 1. All right, so on appeal from the United States District Court for the Southern District of New York. So, you know, Mr. Kelly's in the Eastern District, she's in the Southern. Brief and special appendix for defendant appellant. And these are the attorneys that are on board on her case. You have Arthur L. Adelaila, Diane Fabi Sampson. You have John M. Leventhal. You have the same Adela, whatever. I don't know how to say these people's names. Man, he got the first name of the person's last name. Wow. I don't like doing people's names because, you know, people now say name differently. Okay. Now here is what's in the table content of the appeal. This is the table of content of her appeal. Okay. Remember, it's 113 pages of this. All right. First, it says table of authorities, and it's number 5, a statement of subject matter and appellant jurisdiction. Statement of issue presented for review, statement of the case, then you have the trial itself, number 6, then a summary of the argument. So we're going to look at that. We're going to look at the summary of argument. Then it's the introduction, and it's going to give you all the points. Point 1, all counts should be dismissed pursuant to non-persecution agreement. So there was an agreement that she did with them, and they, I guess, violated that agreement. So and then it's the NPA, I don't know, not non-prosecution agreement. NPA, which is the non-prosecution agreement. So then the appellant may enforce the NPA as a third-party beneficiary. The potential conspirator provision by the USAO, Southern District of New York, and Anabi, I don't know, is not the contrary. To the contrary. Introduction, then Anabib. Yeah, how to say that? Anabib or Anabib? Anabib. Okay. Does not apply to the NPA, was negotiated and entered into outside of the Second Circuit. Then Anabib. I gotta go see what this means. Anabib. Let's just go see this. Let's see. Let's go see what that means. Hold on a second. Let's see what Anabib means. Let's see if they could say it for us. Let's see what the thing. Okay, let's see if it's going to say the word for us. Let's see if it. I don't even see what it means. Wikipedia says Anabib is a surname for the following. That's not helping me. Anabib? It's not. It's not. It says a surname. That's not what it. I don't need no surname. I don't need no surname. Why is it a surname? Yeah, it doesn't give me what Anabib means. Anybody can look it up and tell me what it means? You're just giving me surname. Does it mean anything? Anabib. Okay, so whichever an Anabib mean, I don't know what it means. So, but it does not apply to count 6 because that count falls wholly within the time frame contempt of the NPA. There is affirmative indication that the NPA binds the USAO, Southern District of New York. So her thing is more of the NPA. If it is reasonable to conduct a hearing, then Anabib is tiebreaker that only applies to ambiguity remains after the hearing. All counts fall within the scope of the NPA and must be dismissed. Okay, here comes the second point. Okay, all counts are barred by the statute of limitation. Duh. Okay, section 3283 does not apply to the Mann Act violation. Section 3283 does not apply to the Mann Act violation. Counts 3 and 4. B, the district count erred in applying 3283 retroactively. Okay, Congress indicts an intent that 3283 operate only prospectively. Number 2, the district court's application of 3283 creates in impermissible retroactive effect without authorization from Congress. Count 6 is also barred from the statute of limitation. Defendant was denied her constitutional right to a fair and impartial jury because the jury made false statement in voir dire as to material fact that, if known, would have provided a valid basis to remove him for cause. Juror number 50, false response deprived Ms. Maxwell for her constitutional right to a trial by an impartial juror. Juror 50 did not truthfully answer material question during voir dire. D, under the McDonald test, juror 50 actually implied an inferred bias was established. So we already know there was a lot of biases in Mr. Kelly with the with that what's the name? That show. That remember all those statements that were said in voir dire? Y'all remember that? Y'all, you're not even replying to me. Oh my God. I need some feedback. Right? Okay. Right? Hold on. I gotta get my sound effects. Right?
Yes.
Emmanuel says that I feel like they will never get a jury. You better pay these folks because the jury money will not feed the family. Yep, you are so correct on that. They will not feed the family. But Emmanuel, we're not on that right now. We're on a different topic. We're talking about Ghislaine Maxwell's appeal. We're going over her appeal. All right, so it says here the district court abuses discretion in a manner in which it conducts a post-trial hearing. Number 1, the court erred in precluding defense counsel from questioning juror number 50. Oh my God, y'all. There's a lot of stuff that was done to Robert. Woo! Y'all, did y'all see some of the stuff they're putting in here? Okay. Then F. Oh, the FRE, it says 606 did not prevent inquiry into juror 50's use of prior abuse and persuading jurors to convict Maxwell. So F. The district court erred in finding that 1, juror 50 was not biased, and 2, juror 50 would not have been stricken even if he had answered the question accurately. Point number 4. The court constructively amend counts 3 and 4 of the indictment. So wasn't there some amendment in some of the question that they had asked in the when the jurors came back and asked them some questions about, what does this mean? And the judge did not know, and they made a decision on a certain thing, right? Chow. Yeah. Okay. And then they got the juror's notes. Oh, I didn't know that could be used during the what's the name too. Wow, they collect the juror's note, and that be part of the case. That goes in the appeal. Woo, chow. Do tell Jesus. Y'all, hold on. My head is itching. I put this. I gotta go wash my head, y'all. My head is itching. Gotta put some conditioner or something in it because it's itching. I'm brushing it right now, y'all. Woo, it feels so good to brush it. All right, let's go in here. Let's see. Okay. The applicable law, number 1. The core of criminality of counts 3 and 4 was a scheme to cause underage girls to travel to New York with the intent to violate New York law. There is substantial likelihood that Maxwell was convicted on count 3 and 4 based on the conduct not charged in the indictment. Okay, that's Mr. Kelly. We know that's a whole bunch of Mr. Kelly stuff, remember? A whole bunch of conducts that was never charged. Remember they had 20-something of no conducts? Non-charged conducts? Remember that? Okay, let me see. Let me put my sound, because y'all getting on my nerve. Y'all not even. Let me go give me some sounds. All right, let's go. All right, and then the variance between the proof of trial and allegation in the indictment substantially prejudiced Maxwell. Okay, the sentence should be vacated and remanded of resentencing in the district court erred in applying the incorrect guidelines range and offense. Oh, we already know that's going to be an R. Kelly's thing. They gave the wrong range and outline. Then procedural error, standard of review, the district court improperly applied the level 4 aggressively wrote. Oh, that they did that to Robert in New York case. I mean, Illinois case. And then the conclusion. So later on, I will go over the actual. If y'all want to look at it, let's go look at some stuff in it. Okay, hold on. Let's go look at some stuff. Okay, let's go look at some stuff. Okay, these are all the cases they referred to. They have a lot of case law. Look at that. They got pages and pages of case laws in this. Look at this, y'all. Look. Okay, let's do statement of subject matter and appellant jurisdiction. Okay, this is an appeal from a final judgment in the district court, Allison Julie Nathan and a juror, rendered on June 28, 2022, convicting defendant appellant Ghislaine Maxwell, defendant of conspiracy to transport minor with the intent to engage in criminal sexual activity in violation of Title 18 U.S.C. 371, transportation of a minor with the intent of engaging in criminal sexual activity in violation of Title 18 U.S.C. 423 in sex trafficking a minor, a violation of Title 18 U.S.C. 1591 A, B, 2, And 2, the trial judge imposed concurrent terms of imprisonment of 60 months, 120 months, and 240 months, respectively, to be followed by concurrent terms of supervised release of 3 years and 3 years and 5 years, respectively. The court also imposed a $250,000 fine of $250,000 on each count, totaling $750,000. Timely notice of appeal was filed on July 7, 2022, A420, pursuant to 28 U.S.C. 1291 and Federal Procedure of Appellant P 4B. Oh, that's what the person, that was a last name, y'all. That was a last name, but it's a case. Emmanuel said he can't keep up with the case because there was so many courtrooms. It was so many courtrooms, Emmanuel. It was so many courtrooms. But I'm going to go ahead and end this live. My throat is itching too much, and we can continue with this appeals things later. I just wanted to bring you guys to this information. I was trying to kill time with my missing person. I don't know what happened to him. He never came on. Let me see if my phone ever rang. Okay. I hope he's okay. Oh, it's a lot of people live. Okay, no wonder why I didn't see anybody. Okay. All right, guys. I'm going to have to let you guys go because everybody's leaving me. So I'm going to leave. Since y'all leaving me, I'm leaving too. But thank you to my 29 people who stuck with me, who's hanging in there with me. I'll see you guys later, okay? I just got to go get me something for my itchy throat. I'm going to put my mask on later on. But right now, I'll see you later. Bye, guys.